there was expert under Section 45, and his evidence was corroborated by non-expert evidence under Section 47. Okay, so both are handwriting evidence. So even though it's corroborated, both are handwriting evidence. So in this case, the court actually acquitted the accused, right? Why? Because he said that the corroborative evidence is not enough lah, tak cukup, right? Tak cukup to sustain a conviction, and it's not enough to actually prove the prosecution case beyond reasonable doubt. Okay, so kita jump sekejap pergi the case of Teng Kam Seng. This is where the court made the right decision. Why? Because there is handwriting expert given in this particular case, and the expert evidence on handwriting was corroborated by few corroborative evidence, including voice identification, parade, including the fact of certain circumstantial evidence such as the accused make a phone call at the exact location where the police locate him, and he was seen throwing away a piece of paper containing the numbers of the victim. So ada corroborative evidence. So bila ada corroborative evidence, can the court convict the accused relying on the testimony of the expert? Yes. Right? Okay. I bising tak dekat background because my husband is also having a meeting upstairs. I rasa macam bising. You all dengar bising tak?
But your voice is very clear, doctor, so it's okay.
Alright, okay, thank you. Okay, now kita pergi kepada civil case. Right, so you cannot run away from civil case lah, sebab handwriting pun plaintiff could actually also allege that his signature was forged by the defendant, right, and therefore let's say for example the contracts become voidable. Okay, ataupun there is only where the plaintiff alleged that that was not his signature tapi another cause of action lah, usually dalam contract. Okay, alright, in Dalip Koran Pegawai Polis Daerah Bukit Mertajam, it was observed that evidence by a handwriting expert should be viewed with caution. Such evidence is, however, entitled to be given proper consideration and weight in the context of other evidence available to the court. So nampak tak, dalam civil case, the court can still the court can still rely on handwriting expert. Okay, why? Because in civil case, the court has to decide the case on balance of probability. If the plaintiff has a due expert and the probability is higher that the expert could discharge his duty and prove to the court that the particular signature in issue or handwriting in issue is forged, then the court can decide on in favor of the plaintiff. Okay, so the treatment of handwriting expert ni under Section 45 between criminal case and civil case is quite different. In civil case, you can see from the cases the court use its discretionary power under Section 73 to compare handwriting and to be assisted by the expert under Section 45. So kalau expert tu was actually presented by the plaintiff, coupled with the court's own eyes in comparing the signature under Section 73, the court can make decision whether to make a decision in favor of the plaintiff ataupun defendant on the standard of balance of probabilities. Okay, so students always ask me question, ma'am, kalau dalam civil case, what if both plaintiff and defendant actually bawa expert, right? Then you have to look at both experts lah. So that's why dia kata it was observed that evidence by a handwriting expert should be viewed with caution. However, it is still entitled to be given proper consideration. So the court has to choose one lah. Usually kalau ada conflicting opinion evidence, the court has to choose one. And the reasons for choosing tu must be reflected in the judgment. Okay. Alright, so the treatment tu between criminal and civil cases lain because the outcome of civil and criminal tu lain. Okay, same goes to the case of Shanmugha Nadan dengan United Asia Bank Berhad. Alright, dekat sini dia talk about evidentiary value. Both the cases talk about evidentiary value of a handwriting expert. So both cases actually also agree that yes, handwriting evidence are not that reliable if you compare it to other scientific evidence lah, right? Let's say if you compare it to finger impression or if you compare it to DNA in relation to identity, those are the evidence that are more reliable. So in Dr. Shanmuganathan, the court held based on the case of Murari Lal, it was held that opinion evidence of a handwriting expert should not be acted upon without substantial corroboration, and that it would be hazardous to base a conviction solely on opinion of a handwriting expert. So you need to remember, Dr. Shanmuganathan refers to Murali Lal against state of Madhya Pradesh. This is actually a criminal case. Okay, so in a criminal case, yes, handwriting expert should not be acted upon, right? Opinion evidence on handwriting expert should not be acted upon without corroboration. Tapi kalau dalam civil case, most of the time the court will look at who has the burden to discharge the duty to prove that the handwriting belongs to who. So if the burden is on the plaintiff, it's the plaintiff duty to adduce expert, and if the expert in relation to plaintiff is a reliable expert, can the court rely on his evidence? Of course, boleh ya. Right, siapa yang baru masuk ni? Okay, tak ada. Okay. So same goes to United Asian Bank, Berhad. So if let's say you are faced with questions in relation to handwriting, so first of all you identify whether this is a criminal case or civil case. If it is a criminal case, then you quote criminal cases on handwriting in your law parts. Tapi kalau dia civil case, then you kena quote civil cases lah. Okay, so you tak boleh lah expect me to give marks because there are different positions of treatment of handwriting evidence in criminal case and also in civil case. Okay, boleh ya? Alright, okay, so yang lain ni Sanho Syarikat Perkapalan Timur, you boleh baca sendiri ya. Okay, now kita pergi kepada finger impression ni, yang ni sekejap je, dalam 5 minutes je ya. Alright, fingerprint analysis ni for me, it is actually evidence of fact. Okay, why? Because when fingerprint is lifted, the fingerprint analysis would actually depending on facts perceived by senses, by mata lah, right? Selalunya dia akan, when fingerprint is lifted, dia akan masukkan dalam software and they will compare two finger impression. Satu from let's say the crime scene, atau from the drug, ataupun from the murder weapon. Yang lagi satu, the sample from the accused person. Okay, so bila you compare both, the software yang akan compare, and that's where the software will actually determine points in which the finger impression would actually be the same. Okay, I'm very sure that you have watched movies which shows analysis of finger impression. Yeah? So in relation to fingerprint analysis, of course it is received in courts based on section 9 read together with section 45. Of course, fingerprint analysis is evidence of fact, but it must be given by expert. Okay, right? It becomes opinion evidence because sometimes only partial fingerprint is lifted. So sometimes the expert is giving also an opinion evidence. So from his analysis and from his observation, he would actually give an opinion in relation to the finger impression. Right? Sometimes, alright, they manage to find a lot of fingerprints dekat crime scene. Tapi dekat, let's say, dekat murder weapon, dia jumpa partial fingerprint. Dekat sebelah sini, dia jumpa another partial fingerprints. Dekat sebelah sini, dia jumpa lagi. So they use a technique to combine all the fingerprints that they have lifted and form a complete fingerprints. So that is when the expert would actually give opinion evidence. He will actually explain to the court, right? sample number 1 dekat mana jumpa, sample number 2 dekat mana jumpa, sample number 3 dekat mana jumpa. So by combining methods and put in like a puzzle lah, macam like a puzzle, we form one finger impression. So that is the opinion part. So it is important to note that in relation to finger impression, you can prove one element of the offence, right? In relation to criminal trial, you boleh prove satu je, iaitu element of identity. But you cannot prove other elements. You cannot actually prove that that person actually commits the crime. Okay, I give you a scenario. Let's say, I tak ada pisau pula kat sini. Okay, let's say lah this is knife and this is a murder weapon. Right? I use this particular knife every day. Right? Let's say I cut vegetables, I cut meats I use this knife as a women of the house, contohnya mak dekat rumah ni, let's say I memang use this particular knife. Right? Let's say one day a person died, right, and the knife is on that particular person. Okay, so ada my fingerprints on that. So the presence of fingerprints does not necessarily prove my guilt. It prove what? It prove that I have used this knife. But for what purpose? It has to be differently or separately proved by the accused person. So that's why the presence or sometimes the absence of fingerprint at a crime scene does not necessarily prove guilt ataupun disprove guilt. Okay, so fingerprints can be left on surfaces accidentally, or they may belong to someone who had legitimate access to the area. So therefore, fingerprint evidence should be considered alongside other form of evidence such as eyewitness testimony, DNA, physical, trace, circumstantial evidence. Okay, so it can only prove satu sahaja, identity. It cannot prove more than that. Cannot prove that the accused commit or do not commit that particular crime. Okay, so this is a new case, Mani Maran, anak lelaki Amas, and also the case of Nur Sapiana Yusof. Okay, the example that I give here in relation to the case of Mani Maran, the fingerprint accused was charged with murder. Ada few accused, you nampak kat sini, Mani Maran, anak lelaki Amas and others. Ada few accused person. And the fingerprint of one of the accused person was found in the grill of the back door at the crime scene. Okay, dia punya fingerprint jumpa dekat grill, right? So this was highly relied upon by the prosecution in this particular case. So dia kata because the accused punya fingerprint ada dekat grill, dekat belakang pintu, so accused must have actually be at the crime scene. Okay, so the court agree that yes, the presence of the accused fingerprint shows that the accused is at the crime scene. But it only shows that the accused is at the crime scene. It does not show that the accused committed the murder. Because in this particular case, ada accused yang lain. So the prosecution has not proved beyond reasonable doubt that one of the accused person is actually committing the crime. Okay, boleh faham ya? So ini presence of fingerprint. Right. You compare pula dengan the case of Nur Sapiana Yusof, where this is a case where it is drug related case, but there was no fingerprints and the court still convict the accused. So you see, satu case ada presence of fingerprint tapi the court acquit the accused. Dalam Nur Sapiana Yusof, absence of fingerprint tapi the court convict the accused. So what I want to say is that absence of presence of fingerprint, although it actually kalau you ikut ranking of opinion evidence, fingerprint ni yang paling atas lah, because now evidence of fingerprint could actually come to a degree of exactitude. That means if ada fingerprint, it shows that that particular person is there within the vicinity of a crime, for example. Tapi dalam Nur Sapiana Yusof, no fingerprint. but she still get conviction because the court looks at other evidence which shows the guilt of the accused. Okay, one old case where the court convict the accused based on fingerprint, right, is the case of PP against Toh Kee Huat, and I believe that you have also come upon this particular case dalam evidence 1 masa you buat section 9, identity of person through finger impression. Okay, so this is an appeal case against the decision of the Sessions Court, order of acquittal to the accused. Right, accused was charged for theft of a motor car. Okay, so his fingerprints was found inside a locked car, and that car was stolen at night and was found to be missing the next morning. And on the following day, the car was found abandoned with the glass on the driver's door wound down. The accused's fingerprints was found inside the inner surface of the car. So if you look at the meaning of theft, theft is if you actually move a particular thing from the original position to another position pun dah boleh jadi theft, ya. Right, of course with the exact mens rea lah. Okay, so the court in this particular case, the court acquitted the accused tau on the first trial tu, the within the trial punya stage, the court acquitted the accused. So the prosecution is not satisfied. Why? Because they have presented a compelling evidence to show that this motor car was stolen at night. It was found abandoned the next morning, and what we found was a lot of fingerprints in the inside surface of the car. So it shows that the accused has tampered with the locked car. He has no legitimate access. Of course, he is the one who actually commit the particular theft. Okay, so they appeal on the ground that the court should not have, the court should decide a prima facie. Okay, and in this particular case, the appeal of the prosecution was allowed. The case was ordered for retrial, and the trial court decide a prima facie, and the defense has to answer the case lah. Okay, so ini memang case PP against Toh Kee Huat adalah I would say a leading case on finger impression in Malaysia. Okay, tapi again you have to remember, absence or presence of fingerprints does not actually affect conviction ataupun acquittal. Right, you have to look at evidence of finger impression with other evidence. Okay, so with habis finger impression, kita habislah the first requirement under section 45, which is subject matter. So to recap back, ada 4 subject matter, foreign law, science or art, handwriting, and also finger impression. And different cases would actually be applicable depending on the nature of the case, depending on subject matter of the proceeding as well. Right, macam foreign law, I told you before this, it is not limited to the law of foreign country. For science or art, it should have been interpreted liberal enough, looking at the case of Chandrasekaran. Untuk handwriting analysis pula, ada 2 attitude of the court in criminal case and also in civil case. Untuk finger impression, although this particular evidence weighs or due weight should be given for this evidence, it may actually absence of fingerprint actually can still secure conviction, ataupun presence of fingerprints does not guarantee the prosecution case is strong. Okay, right, now kita pergi kepada qualifications of expert, right, which is the second requirement of section 45. Okay, so for this one, you need to know that experts must be qualified. Qualified by what? Ada 3. Right, academic qualifications, experience, ataupun special training. Okay, sometimes dia academic qualification dia adalah chemist tapi dia ada training on document examination. That means dia boleh bagi evidence on handwriting. Okay. Sometimes dia punya academic qualification is general forensic science tapi by special training dia ada training like macam a thorough rigorous training on bullet identification. So antara salah satu tiga ni, kalau ada tiga-tiga lagi bagus, the evidence are put a more weight are put to that particular kind of expert lah yang ada tiga-tiga qualifications. Okay, so the law is an expert must be skilled in his field. Right, kalau dia bagi on bullet examination, then dia kena skill dengan bullet examination lah. Right, if the law required in that particular, the field required in that particular case is psychiatrist evaluation, and the fact that dia adalah psychologist tak adalah cukup enough to actually give an assessment of a psychiatric evaluation. So you kena tengok expert punya qualifications tu must tally with the field required by that particular case. Okay, right. However, the skills required ataupun qualifications required is minimal, bukanlah maximum, minimal. This can be seen in the case of Junaidi bin Abdullah against public prosecutor, where the appellant in this particular case was convicted for possession of firearm under ISA. So appellant accused appeal and the particular appeal was on the ground that Mr. Chong, who is a government chemist in this particular case, his evidence should not be admissible because it was contended by the defense that he is only a chemist. He is not an armorer. Okay, kenapa? Because the field is in relation to serviceability of a revolver. Okay, whether that particular revolver was recently used or not. Okay, so Mr. Chong is a chemist. He gives evidence on that. Right. However, in this particular case, that the court held that the evidence sought to be proved by the prosecution is only limited to the serviceability of an ordinary revolver, and by special training ataupun by experience, chemist was competent to give expert evidence on such uncomplicated matters. It's not that he needs to identify whether a particular bullet was fired from a particular revolver. Yang itu identification of bullets ataupun identification of guns lah, right? Itu complicated. But in matters on serviceability of an ordinary revolver, the court held that a chemist would have such experience. So you know, from the case of Junaidi, the qualifications required is minimal qualification. Okay, right. Now kita pergi kepada few other cases where the court gave principles. And in Sam Hong Choi, the court held that the chief inspector of police, who was also an assistant armourer, was competent to give evidence on serviceability of a pistol. PP against Muhammad Sulaiman lay down the test. What is the test that actually the court would ask himself in relation to qualifications of expert? So the court said that the test is very simple. I need to ask myself, is he an expert? Ataupun dalam Latin word the question is he peritus? Right? The English translation of it is he an expert? If the answer is yes, then he is an expert. Okay? So the court will look at what is his qualifications. Academically, would it be tally to the field? If not, has he received some kind of training? If not, has he some experience, or has he actually an expert sought after in this particular field? If the answer is yes, then a person could be regarded as expert. Okay. And in the case of Dato' Mokhtar Hashim, the court held that competency of expert, that means whether or not expert is specially skilled in the field, is a preliminary question that must be asked by litigators. Okay, so that's why bila you abuse expert in practice, let's say you need an an assistance by the expert to establish your case or to prove your case. After you have asked his name or her name, what question should you ask is in relation to his expertise. Okay, can you explain to court where you graduated from? What is the degree that you graduated from? Let's say ITM. Can you tell a little bit on your study for this particular degree? After that, do you continue your master's studies? Or do you have any PhD? Have you published any writings? Have you given evidence in court before? How many times has your evidence been sought by the court? Was it admissible? So what you are trying to do is you are trying to establish that the witness here, your expert, is an expert and can be relied on by the court, because that's the requirement under section 455. Subject matter, then whether or not he is qualified. Okay, right. In any case, Chong Wei Kian, even a chemist for 18 years has established his qualification. If he right. The case of Chong Wei Kian is, I would say, outdated because after Section 399 was enacted and listed down gazetted expert, if he is a chemist ataupun by medical practitioners in government hospital, right, he is deemed to be an expert because they dalam gazette dalam Section 399 of the Criminal Procedure Code. Okay, but to be safe, if let's say you are qualified doctor ataupun chemist, even though they are attached to government, you still have to establish this qualification. So we do not want an attack from the defense. Like say you are prosecutor, we do not want an attack to the defense. Kalau usually defense, of course, would actually establish the prosecution expertise and expert lah. Okay, and for that could also look at his competency and you blame dalam competency. Kalau you ingat belajar pasal child custody hari tu, the wife suffered incurable mental illness, but the plaintiff called siapa? Nurse. Dalam competency dia the court held that nurse is semi-professional. So boleh kena case of competency where big against money on finger impression. The person who lifted out the fingerprints was not that experienced, so they that evidence by that person. But the court held that if you take the experience, you have academic knowledge, or you have a social training, that is also acceptable under Section 45. Okay. Right. This is where I dahulukan. Evidence of expertise of the witness must be given as a preliminary issue. Okay. After you ask the witness, let's say this is during examination in chief. After you ask the witness, what is your name, what is your age, what is your occupation, then you start to establish the expertise. Right. So you can establish lah. Right. What is your where do you graduated from? What is the degree that you hold? What is your master? If you have PhD, have you written any paper? Have you been interviewed by any local or international newspaper? Have you been featured as expert in this particular area? Are you attached to any overseas university or overseas organization? This is to establish expertise. And the more you establish the expertise, the more weight the particular evidence would stand. Yeah, right. Okay, itu sahaja. Okay, one more thing in relation to qualifications, the court may also take judicial notice of the fact that an expert has previously given evidence. Right. For example, in Kong Mensu, I told you before, in the case litigation on Kong Mensu, Dato' in that particular case has given evidence previously in the same court for child custom. So the same judges the same judge hear the same witness. And he, in his previous case, he had decided that this witness is an expert. So dia boleh take judicial notice lah. Dia boleh kata, alright, Datuk Ling has previously appeared in my court. In the previous case, I have decided that Datuk Ling is an expert in the area of Fuchau custom. Defense, do you have any objection to make to this? Kalau defense kata, we haven't encountered, let's say, this witness before. Can we cross-examine this witness to establish his expertise? Then the court has to actually give the chances to the defense untuk bagilah. Alright? So if the witness has appeared so many times at the same court in front of the same judge, the judge may take judicial notice of the expertise of that particular witness ataupun that particular expert. Right. Mode of giving expert evidence, ini cara macam mana, because you are going to, I don't want to say coach your witness lah, but I would say you would want to give some guidelines to your witness of what is actually happening in court, especially if your witness is a new witness. Okay, dia baru first time nak jadi expert witness, so you might want to brief him. So this is this is what you are going to do in court when you introduce opinion evidence. Right, so the expert of course must first start his testimony by introducing himself, then his qualifications, then his experience. So soalan yang you tanya tu kena fulfill this particular guidelines lah, right? So you kena boleh perkenalkan diri di mahkamah, right? Because in mahkamah, especially lower court, magistrate sessions, and magistrates and sessions, and also to certain extent high court, soalan dalam BM, soalan examination in chief and cross examination. So sometimes I akan converse in BM to actually give you example of what happened in the court. So let's say you are the prosecutor ataupun you are the defense, you are introducing your expert. Okay, so this is what you ask in court. Boleh perkenalkan diri, nama, umur dan pekerjaan. Okay, dia dah jawab tu, right? Because this is question for evidence in examination in chief. Examination in chief punya soalan mesti open ended. Dia tak boleh, adakah anda setuju? Itu adalah soalan dalam cross examination. So lepas tu you akan tanyalah all the questions that I have mentioned before. Okay, daripada mana boleh terangkan kepada mahkamah kelayakan akademik tuan. Boleh terangkan kepada mahkamah berapa tahun tuan bekerja sebagai ahli kimia, right? Berapa tahun tuan telah memberi keterangan di mahkamah. Sudah berapa banyak kali tuan memberi keterangan di mahkamah. So jadi these are to establish the expertise. Then the testimony proceeded to the subject of the expertise lah. Okay, so bila tuan mendapat sampel ini, siapa yang memberi sampel ini, bilakah autopsi dijalankan, right? Siapa lagi yang hadir semasa sesi autopsi, adakah sesi autopsi ini direkodkan, right? So ini adalah you go to the subject matter lah. So subject matter tu mesti bawah section 45, whether it's science or art, foreign law, finger impression ataupun handwriting. Okay, expert then proceed to give his opinion. Lepas dia terangkan all the matters related to the subject matter, then dia akan proceed untuk bagi opinion, right? After the autopsy was done, in my opinion, the particular victim died because of smoke inhalation. Okay, and this is from my observation that the, let's say, airways, right, to the lungs is filled with, let's say, black residue. You cakap macam tu. That's why I concluded, and in my opinion, that the victim died from smoke inhalation. Okay, so dia akan proceed untuk bagi dia punya opinion. Okay, and he would actually support his opinion with reasons and grounds. Okay, from my experience, the airways turns black, right, if the victim ataupun the particular person in question is a heavy smoker, or dia bagilah reason apa. From the testimony of siapa, he is not a heavy smoker, right? Lungs pun not badly affected, so bukan heavy smoker. So this must be a smoke inhalation. Contohnya lah, right? So dia akan bagi grounds to support his opinion. And when he give grounds, it is not necessary for the expert to produce data. Okay, kalau dia produce data, dia produce materials, he produce other examination, it's very good. Okay, but it does not necessarily have to be other documents or other testimony from other experts. Yeah. However, of course, it is advisable for experts to prepare detailed account in relation to his examination in case the opposing party attacks during cross-examination. Okay, right, now kita pergi the last, I think last kot. Okay, second last. Okay, yang ni sikit je Alright, conflicting opinion evidence, subtopic in relation to expert evidence. Okay, it is not I think it's normal usually because the parties wants to establish their case. So it's normal for the parties to bring their expert, and sometimes this expert gives biased testimony. Okay, so prosecution expert akan side dengan prosecution case. Defense expert akan side dengan defense punya case. So if let's say the court is faced with two conflicting opinion evidence, what should the court do? Okay, what should the court do? Alright, in the case of Singapore Finance and the case of Collector of Land Revenue and Alagappa Chettiar, both these cases stated that where there is conflicting expert testimony, the court has a right to prefer one opinion over the other. Right? So these two cases is that you can choose one because you are the trier of fact. You can see the witness, you can evaluate the witness, you can know whether the witness is lying or not, you can know whether the witness is giving consistent or inconsistent evidence. If that is so, you are the one who can choose one over the other. Right? Even if let's say both are giving compelling evidence, there must be other evidence which actually support the testimony of the expert. Right? So let's say both are equally compelling, both are equally qualified. They are giving, even though they are giving totally different testimony, other evidence might have support or might be conflicted with the testimony of the accused person. The testimony of the expert. Right? So in that particular situation, the trier of fact, which is the judge lah, alright, be it magistrate, sessions court judge or high court judge, would actually be in the position to choose one over the other. Right? So in the case of Collector of Land Revenue and Alagappa Chettiar, Lord Diplock stated that a finding that the opinion of one expert witness is to be preferred to that of another is also one which usually is not disturbed by an appellate court unless it can be demonstrated that the judge who heard and saw them give their evidence has misunderstood it, or that his reasons for preferring one to the other are clearly unsound. So usually memang trier of fact yang decide. I choose prosecution expert or I choose plaintiff expert. Why? Because dia ada the advantage of hearing and witnessing the witness. Okay, and this should not be disturbed by appellate court. Right? However, there are some cases where the trier of fact has misjudged the opinion given by this expert, and it is the duty for the appellate court to interrupt. Okay, all right, so these are other options available to the court when faced with two conflicting opinion evidence. So the first one is choose one over the other lah, right? Number two, the court may order the party or parties to call additional experts. Right? You can see the case of Pavon against PP for that. Right? Just jot down. I might actually ask you what happened in that particular case. All right. The court could also call its own experts, right? In civil trial, dalam rules of court, you boleh tengok order 40 and order 40 capital A, which give power for the court to call its own experts. Ataupun lastly, and this is least preferable options when the court is faced with two conflicting opinion, the court may come out with his own opinion after due regard has been taken on the conflicting opinion. Right? Yang paling selalu or the most suitable choice is option A. The court can choose one over the other, and this one ada banyak authorities, right, for you to base the options. Right. Nanti dalam tutorial, I would want to ask you questions in relation to the case of Nilai 3 Porcelain and Berjaya Sompo Insurance, and also the case of PP against Datuk Seri Anwar Ibrahim. Those with textbook would actually see these two cases. I ambil satu civil, satu criminal to show that the court can choose one over the other and give reasons why he chose one over the other. And the other case, Datuk Seri Anwar Ibrahim, right? I told you before this kan yang it should not be disturbed by an appellate court, right? The case of Datuk Seri Anwar Ibrahim is where the trial judge has made decision but was disturbed by the appellate court in relation to the choice that the trial court made, right? So please read these two cases, and this is the case where selalunya bila ada conflicting opinion evidence, it becomes the basis for students to write it in their answer. Okay, so I will definitely ask you during the tutorial what happens in Nilai 3 Porcelain, what happens in PP against Datuk Seri Anwar Ibrahim, why the court choose the expert that they choose in that particular case. Okay, all right. If let's say the court choose the first option is choosing one over the other, right? What are the factors that the court consider? These are the factors, right? The court would first, of course, will look at qualifications and expertise. If the plaintiff expert is more qualified compared to defendant expert, the court would of course side with his decisions. Okay. If let's say they are both academically, experience-wise, special training-wise, that they are both equally good, then the court will look at next reliability and credibility. So this is question of fact lah, right? Whether the expert is consistent witness, do they provide grounds for their opinion, what are the methodology used, what is the opinion of other author or other expert on this particular area. Okay. Next, the court will look at consistency and coherence. The court will also consider consistency and coherence of each expert evidence and the internal logic and coherence with other evidence presented in the case. Sometimes expert ni, dia bagi evidence because usually expert is paid by the parties, especially in civil trial. Plaintiff akan ada dia punya own expert, defendant akan ada dia punya own expert. They paid their expert to come to court. Right, so of course the expert would actually try to adjust dia punya opinion in favor of the parties. Okay, so sometimes without realizing it, they are not consistent with their own evidence. They are not giving consistent evidence with other evidence, right? So the court will also look at this particular factor. And lastly, of course, bias or interest, especially if the expert itself is also one of the named defendant ataupun the expert is the employee of the defendant, right? Contohnya lah hospital kena sue, hospital the one yang jadi expert adalah the doctor of that particular hospital. Of course, dia akan jadi bias. So the bias, the court will assess whether any bias or interest may have influenced the expert's evidence, such as financial interest or personal relationship with one of the parties. Okay? Alright. What are the functions of the court in evaluating expert evidence? Ni lepas dah bagi that means the evidence is relevant. The expert is giving evidence under the subject matter mentioned in section 45. He is also qualified. And then the evidence is admissible. So what is the function of the court after the evidence is admissible? The court needs to evaluate it. So the court must consider the reasons of the expert before coming to a finding. In the case of Sim Aho, Justice Adams stated that the expert should have been asked by the prosecutor to elaborate and give reasons as to why he said that in this particular case that the odd pieces of paper were in fact documents relating to public lottery, and the learned president of the Sessions Court should have considered these reasons before he came to his findings. Right? Nampak tak dekat case ni dia macam appeal case. Bukan macam, memang appeal case where the defense argued that the learned Sessions Court president has not evaluated properly the evidence given by the expert, and he is giving due weight to expert evidence who do not provide reasons for his opinion. So he appeal on the ground that expert does not provide grounds for his opinion. The court has not properly evaluated the expert evidence, right? So other cases, you can look at Samundi Devan, Asian Securities Paper Mills, and CGU Insurance, yeah. Okay, and lastly, right, kita tengok the evidentiary value of expert evidence. Of course, you have to differentiate this with types of subject matter. If you are talking about finger impression, the evidentiary value of this evidence might be high. Tapi kalau you talk about handwriting, the evidentiary value might be low. Right? Why? Because many people write alike. So analysis on handwriting, even though it's backed up by science, right, or even though that particular person is specially skilled in analysis of handwriting, it cannot come to a conclusive approach. Okay, so evidentiary value would depends on types of evidence, would depends on subject matter. Right, so you can refer to all these cases in deciding whether the court should give due evidentiary value or should give low evidentiary value. Like in the case of PP against Muhammad Qasim bin Yatim, the court was of the view that evidence of experts can never go beyond an opinion and can never therefore be absolute certainty. Right. Kenapa court cakap macam tu? Because in Muhammad Qasim bin Yatim, the expert is giving evidence on handwriting. Right. Tapi if the matter is on DNA or finger impression or autopsy, for example, right, the court might put a due evidentiary value, a high evidentiary value. Right? So if the matter is too complex, is too scientific, the least the court could do is to give high evidentiary value to the expert evidence because he himself would not have that kind of knowledge, right? So in Junaidi Abdullah, the court held that lack of qualification or experience only affects weight. It does not affect admissibility. Ingat tak Junaidi Abdullah, subject matter is on serviceability of a revolver tapi the expert is chemist, right? Dia lack qualification. Bukan dia tak ada qualification, dia lack of qualification affects weight. Dia tak affect admissibility. Okay? Alright. I will cover section 46 next week, but next week other section tu sebenarnya sikit-sikit je. Alright? Okay. Any question? Right? Kita ada lebih kurang 5 to 6 minutes before 3. Any question? Alright, yes, Siti Khadijah.
Sorry, doctor. Can you explain why in Chong Wei Kian the 18 years of experience does not make him an expert?
Because it was not asked in the court. Right? Dia macam, oh, I have 18 years of experience, that's why I am an expert. Faham tak? Dia assume. Right? Bila qualifications cannot be based on assumption. It has to be proved in court. Right? So the prosecution should actually ask the question to the witnesses. Right? So let's say a chemist call. The position is quite different sikit Khadijah sekarang, because chemists now, especially those attached in Jabatan Kimia, is a gazetted expert, right, under section 399 of the CPC. Right, Chong Wei Kian was decided in 1990s macam tu. Right, so when the expert just give evidence on the assumption that he is experienced, the qualification has not been established. You have to remember that section 45 has two elements. One is the element of subject matter, the other one is the element of qualifications. Both has to be proved by evidence lah. Okay, so qualifications tu you kena tanya soalan lah. Right, kena tanya, you have to ask question during examination in chief. What is your occupation? How many years have you been attached as a chemist, right? How many cases have you handled? And when you ask that particular questions, qualifications has been established, right? You cannot just assume that because of the job that particular expert, for example, has dealt with a particular subject matter, right? Because chemist ni ada banyak chemist, right? Ada banyak departments. Okay, so let's say he is a chemist for 18 years, but he never tested a single drug, right? So experience-wise pun, he might have a lack of qualifications. Boleh?
Faham, doctor.
Alright, lagi? Yes, Nurin. Adlina, sorry.
Doctor, sometimes I get confused in the handwriting. Why is there a difference in attitude between civil and criminal case?
Because, as I said just now, because of the outcome of the case. In civil trial, the defendant is subjected to maybe paying damages, right? There would not be any criminal consequences, okay? Tapi in criminal case, the outcome of the case is that the accused is subjected to conviction, right? If you look at from the point of view of burden of proof pun, the burden in relation to criminal case is beyond reasonable doubt. So you need to be some kind, you need to be sure that the handwriting was forged, for example, right? So nanti kita belum sampai lagi topik beyond reasonable doubt and what is balance of probabilities, okay? But if there is a doubt that the accused has not forged the signature, then that's why you need a corroborative evidence. So that's why a difference of attitude in relation to criminal and also civil case dalam handwriting punya expert. So dalam civil, on top of expert giving evidence, the court usually use its power using dia punya bare eyes to compare handwriting. Okay, tapi usually in civil cases, if you read cases lah, ada banyak cases on handwriting. Dr. Shanmuganathan, United Asia Bank tu is just few of them. If you read more in detail in relation to civil cases, it has been decided over and over again that at least it needs to be supported with other evidence as well, right? But not as severe as in criminal cases lah. The requirement is not as severe as in criminal cases. Boleh Adlina?
Oh, boleh doktor. Thank you doktor.
Lagi? Soalan lain? Alright, okay. So if there is any question, right, and you are trying to digest the